Republic Act No. 10607. An act strengthening the insurance industry, further amending Presidential Decree No. 612, otherwise known as the Insurance Code, as amended by Presidential Decree NOS 1141, 1280, 1455, 1460, 1814 and 1981, and Batas Pambanza BLG 874, and for other purposes. Be it enacted by the Senate and House of Representatives of the Philippines in Congress assembled. Section 1. Presidential Decree No. 612, as amended, is hereby further amended to read as follows. General Provisions. Section 1. This decree shall be known as the Insurance Code. SEC 2. Whenever used in this code, the following terms shall have the respective meanings hereinafter set forth or indicated, unless the context otherwise requires. A contract of insurance is an agreement whereby one undertakes for a consideration to indemnify another against loss, damage, or liability arising from an unknown or contingent event. A contract of suretyship shall be deemed to be an insurance contract, within the meaning of this code, only if made by a surety who or which, as such, is doing an insurance business as hereinafter provided. B. The term doing an insurance business or transacting an insurance business, within the meaning of this code, shall include 1. Making or proposing to make, as insurer, any insurance contract. 2. Making or proposing to make, as surety, any contract of suretyship as a vocation and not as merely incidental to any other legitimate business or activity of the surety. 3. Doing any kind of business, including a reinsurance business, specifically recognized as constituting the doing of an insurance business within the meaning of this code. 4. Doing or proposing to do any business in substance equivalent to any of the foregoing in a manner designed to evade the provisions of this code. In the application of the provisions of this code, the fact that no profit is derived from the making of insurance contracts, agreements, or transactions, or that no separate or direct consideration is received therefore, shall not be deemed conclusive to show that the making thereof does not constitute the doing or transacting of an insurance business. C. As used in this code, the term commissioner means the insurance commissioner. Chapter I. The Contract of Insurance. Title 1. What may be insured? SEC 3. Any contingent or unknown event, whether past or future, which may damnify a person having an insurable interest, or create a liability against him, may be insured against, subject to the provisions of this chapter. The consent of the spouse is not necessary for the validity of an insurance policy taken out by a married person on his or her life or that of his or her children. All rights, title, and interest in the policy of insurance taken out by an original owner on the life or health of the person insured shall automatically vest in the latter upon the death of the original owner, unless otherwise provided for in the policy. SEC 4. The preceding section does not authorize an insurance for or against the drawing of any lottery, or for or against any chance or ticket in a lottery drawing a prize. SEC 5. All kinds of insurance are subject to the provisions of this chapter so far as the provisions can apply. Title 2. Parties to the contract. SEC 6. Every corporation, partnership, or association, duly authorized to transact insurance business as elsewhere provided in this code, may be an insurer. SEC 7. Anyone except a public enemy may be insured. SEC 8. Unless the policy otherwise provides, where a mortgagor of property affects insurance in his own name providing that the loss shall be payable to the mortgagee, or assigns a policy of insurance to a mortgagee, the insurance is deemed to be upon the interest of the mortgagor, who does not cease to be a party to the original contract, and any act of his, prior to the loss, which would otherwise avoid the insurance, will have the same effect, although the property is in the hands of the mortgagee. But any act which, under the contract of insurance, is to be performed by the mortgagor, may be performed by the mortgagee therein named, with the same effect as if it had been performed by the mortgager. SEC 9. If an insurer assents to the transfer of an insurance from a mortgager to a mortgagee, and, at the time of his assent, imposes further obligations on the assignee, making a new contract with him, the acts of the mortgager cannot affect the rights of said assignee. Title 3. Insurable interest. SEC 10. Every person has an insurable interest in the life and health. A. Of himself, of his spouse and of his children. B. Of any person on whom he depends wholly or in part for education or support, or in whom he has a pecuniary interest. C. Of any person under a legal obligation to him for the payment of money, or respecting property or services, of which death or illness might delay or prevent the performance, and D. Of any person upon whose life any estate or interest vested in him depends. SEC 11. The insured shall have the right to change the beneficiary he designated in the policy, unless he has expressly waived this right in said policy. Notwithstanding the foregoing, in the event the insured does not change the beneficiary during his lifetime, the designation shall be deemed irrevocable. SEC 12. The interest of a beneficiary in a life insurance policy shall be forfeited when the beneficiary is the principal, accomplice, or accessory in willfully bringing about the death of the insured. In such a case, the share forfeited shall pass on to the other beneficiaries, unless otherwise disqualified. In the absence of other beneficiaries, the proceeds shall be paid in accordance with the policy contract. If the policy contract is silent, the proceeds shall be paid to the estate of the insured. SEC 13. Every interest in property, whether real or personal, or any relation thereto, or liability in respect thereof, of such nature that a contemplated peril might directly damnify the insured, is an insurable interest. SEC 14. An insurable interest in property may consist in A. An existing interest. B. An inchoate interest founded on an existing interest, or C. An expectancy, coupled with an existing interest in that out of which the expectancy arises. SEC 15. A carrier or depository of any kind has an insurable interest in a thing held by him as such, to the extent of his liability but not to exceed the value thereof. SEC 16. A mere contingent or expectant interest in anything, not founded on an actual right to the thing, nor upon any valid contract for it, is not insurable. SEC 17. The measure of an insurable interest in property is the extent to which the insured might be damnified by loss or injury thereof. SEC 18. No contract or policy of insurance on property shall be enforceable except for the benefit of some person having an insurable interest in the property insured. SEC 19. An interest in property insured must exist when the insurance takes effect, and when the loss occurs, but need not exist in the meantime. An interest in the life or health of a person insured must exist when the insurance takes effect, but need not exist thereafter or when the loss occurs. SEC 20. Except in the cases specified in the next 4 sections, and in the cases of life, accident, and health insurance, a change of interest in any part of a thing insured unaccompanied by a corresponding change of interest in the insurance, suspends the insurance to an equivalent extent, until the interest in the thing and the interest in the insurance are vested in the same person. SEC 21. A change of interest in a thing insured, after the occurrence of an injury which results in a loss, does not affect the right of the insured to indemnity for the loss. SEC 22. A change of interest in one or more of several distinct things, separately insured by one policy, does not avoid the insurance as to the others. SEC 23. A change of interest, by will or succession, on the death of the insured, does not avoid an insurance, and his interest in the insurance passes to the person taking his interest in the thing insured. SEC 24. A transfer of interest by one of several partners, joint owners, or owners in common, who are jointly insured, to the others, does not avoid an insurance even though it has been agreed that the insurance shall cease upon an alienation of the thing insured. SEC 25. Every stipulation in a policy of insurance for the payment of loss whether the person insured has or has not any interest in the property insured, or that the policy shall be received as proof of such interest, and every policy executed by way of gaming or wagering, is void. Title 4. Concealment. SEC 26. A neglect to communicate that which a party knows and ought to communicate, is called a concealment. SEC 27. A concealment whether intentional or unintentional entitles the injured party to rescind a contract of insurance. SEC 28. Each party to a contract of insurance must communicate to the other, in good faith, all facts within his knowledge which are material to the contract and as to which he makes no warranty, and which the other has not the means of ascertaining. SEC 29. An intentional and fraudulent omission, on the part of one insured, to communicate information of matters proving or tending to prove the falsity of a warranty, entitles the insurer to rescind. SEC 30. Neither party to a contract of insurance is bound to communicate information of the matters following, except in answer to the inquiries of the other. A. Those which the other knows. B. Those which, in the exercise of ordinary care, the other ought to know, and of which the former has no reason to suppose him ignorant. C. Those of which the other waives communication. D. Those which prove or tend to prove the existence of a risk excluded by a warranty, and which are not otherwise material, and E. Those which relate to a risk accepted from the policy and which are not otherwise material. SEC 31. Materiality is to be determined not by the event, but solely by the probable and reasonable influence of the facts upon the party to whom the communication is due, in forming his estimate of the disadvantages of the proposed contract, or in making his inquiries. SEC 32. Each party to a contract of insurance is bound to know all the general causes which are open to his inquiry, equally with that of the other, and which may affect the political or material perils contemplated, and all general usages of trade. SEC 33. The right to information of material facts may be waived, either by the terms of insurance or by neglect to make inquiry as to such facts, where they are distinctly implied in other facts of which information is communicated. SEC 34. Information of the nature or amount of the interest of one insured need not be communicated unless in answer to an inquiry, except as prescribed by Section 51. SEC 35. Neither party to a contract of insurance is bound to communicate, even upon inquiry, information of his own judgment upon the matters in question. Title 5. Representation. SEC 36. A representation may be oral or written. SEC 37. A representation may be made at the time of, or before, issuance of the policy. SEC 38. The language of a representation is to be interpreted by the same rules as the language of contracts in general. SEC 39. A representation as to the future is to be deemed a promise, unless it appears that it was merely a statement of belief or expectation. SEC 40. A representation cannot qualify an express provision in a contract of insurance, but it may qualify an implied warranty. SEC 41. A representation may be altered or withdrawn before the insurance is effected, but not afterwards. SEC 42. A representation must be presumed to refer to the date on which the contract goes into effect. SEC 43. When a person insured has no personal knowledge of a fact, he may nevertheless repeat information which he has upon the subject, and which he believes to be true, with the explanation that he does so on the information of others, or he may submit the information, in its whole extent, to the insurer, and in neither case is he responsible for its truth, unless it proceeds from an agent of the insured, whose duty it is to give the information. SEC 44. A representation is to be deemed false when the facts fail to correspond with its assertions or stipulations. SEC 45. If a representation is false in a material point, whether affirmative or promissory, the injured party is entitled to rescind a contract from the time when the representation becomes false. SEC 46. The materiality of a representation is determined by the same rules as the materiality of a concealment. SEC 47. The provisions of this chapter apply as well to a modification of a contract of insurance as to its original formation. SEC 48. Whenever a right to rescind a contract of insurance is given to the insurer by any provision of this chapter, such right must be exercised previous to the commencement of an action on the contract. After a policy of life insurance made payable on the death of the insured shall have been enforced during the lifetime of the insured for a period of 2 years from the date of its issue or of its last reinstatement, the insurer cannot prove that the policy is void ab initio or is rescindable by reason of the fraudulent concealment or misrepresentation of the insured or his agent. Title 6. The policy. SEC 49. The written instrument in which a contract of insurance is set forth, is called a policy of insurance. SEC 50. The policy shall be in printed form which may contain blank spaces, and any word, phrase, clause, mark, sign, symbol, signature, number, or word necessary to complete the contract of insurance shall be written on the blank spaces provided therein. Any rider, clause, warranty, or endorsement purporting to be part of the contract of insurance and which is pasted or attached to said policy is not binding on the insured, unless the descriptive title or name of the rider, clause, warranty, or endorsement is also mentioned and written on the blank spaces provided in the policy. Unless applied for by the insured or owner, any rider, clause, warranty, or endorsement issued after the original policy shall be countersigned by the insured or owner, which countersignature shall be taken as his agreement to the contents of such rider, clause, warranty, or endorsement. Notwithstanding the foregoing, the policy may be in electronic form subject to the pertinent provisions of Republic Act No. 8792, otherwise known as the Electronic Commerce Act, and to such rules and regulations as may be prescribed by the Commissioner. SEC 51. A policy of insurance must specify: A. The parties between whom the contract is made. B. The amount to be insured except in the cases of open or running policies. C. The premium, or if the insurance is of a character where the exact premium is only determinable upon the termination of the contract, a statement of the basis and rates upon which the final premium is to be determined. D. The property or life insured. E. The interest of the insured in property insured, if he is not the absolute owner thereof. F. The risks insured against, and G. The period during which the insurance is to continue. SEC 52. Cover notes may be issued to bind insurance temporarily pending the issuance of the policy. Within 60 days after issue of a cover note, a policy shall be issued in lieu thereof, including within its terms the identical insurance bound under the cover note and the premium therefor. Cover notes may be extended or renewed beyond such 60 days with the written approval of the Commissioner if he determines that such extension is not contrary to and is not for the purpose of violating any provisions of this code. The Commissioner may promulgate rules and regulations governing such extensions for the purpose of preventing such violations and may by such rules and regulations dispense with the requirement of written approval by him in the case of extension in compliance with such rules and regulations. SEC 53. The insurance proceeds shall be applied exclusively to the proper interest of the person in whose name or for whose benefit it is made unless otherwise specified in the policy. SEC 54. When an insurance contract is executed with an agent or trustee as the insured, the fact that his principal or beneficiary is the real party in interest may be indicated by describing the insured as agent or trustee, or by other general words in the policy. SEC 55. To render an insurance effected by one partner or part owner, applicable to the interest of his CO partners or other part owners, it is necessary that the terms of the policy should be such as are applicable to the joint or common interest. SEC 56. when the description of the insured in a policy is so general that it may comprehend any person or any class of persons, only he who can show that it was intended to include him, can claim the benefit of the policy. SEC 57. A policy may be so framed that it will inure to the benefit of whomsoever, during the continuance of the risk, may become the owner of the interest insured. SEC 58. The mere transfer of a thing insured does not transfer the policy, but suspends it until the same person becomes the owner of both the policy and the thing insured. SEC 59. A policy is either open, valued or running. SEC 60. An open policy is one in which the value of the thing insured is not agreed upon, and the amount of the insurance merely represents the insurer's maximum liability. The value of such thing insured shall be ascertained at the time of the loss. SEC 61. A valued policy is one which expresses on its face an agreement that the thing insured shall be valued at a specific sum. SEC 62. A running policy is one which contemplates successive insurances, and which provides that the object of the policy may be from time to time defined, especially as to the subjects of insurance, by additional statements or endorsements. SEC 63. A condition, stipulation, or agreement in any policy of insurance, limiting the time for commencing an action thereunder to a period of less than 1 year from the time when the cause of action accrues, is void. SEC 64. No policy of insurance other than life shall be cancelled by the insurer except upon prior notice thereof to the insured, and no notice of cancellation shall be effective unless it is based on the occurrence, after the effective date of the policy, of one or more of the following. A. Non-payment of premium. B. Conviction of a crime arising out of acts increasing the hazard insured against. C. Discovery of fraud or material misrepresentation. D. Discovery of willful or reckless acts or omissions increasing the hazard insured against. E. Physical changes in the property insured which result in the property becoming uninsurable. F. Discovery of other insurance coverage that makes the total insurance in excess of the value of the property insured, or G. A determination by the Commissioner that the continuation of the policy would violate or would place the insurer in violation of this code. SEC 65. All notices of cancellation mentioned in the preceding section shall be in writing, mailed or delivered to the named insured at the address shown in the policy, or to his broker provided the broker is authorized in writing by the policy owner to receive the notice of cancellation on his behalf, and shall state A. Which of the grounds set forth in section 64 is relied upon, and B. That, upon written request of the named insured, the insurer will furnish the facts on which the cancellation is based. SEC 66. In case of insurance other than life, unless the insurer at least 45 days in advance of the end of the policy period mails or delivers to the named insured at the address shown in the policy notice of its intention not to renew the policy or to condition its renewal upon reduction of limits or elimination of coverages, the named insured shall be entitled to renew the policy upon payment of the premium due on the effective date of the renewal. Any policy written for a term of less than 1 year shall be considered as if written for a term of 1 year. Any policy written for a term longer than 1 year or any policy with no fixed expiration date shall be considered as if written for successive policy periods or terms of 1 year. Title 7. Warranties. SEC 67. A warranty is either expressed or implied. SEC 68. A warranty may relate to the past, the present, the future, or to any or all of these. SEC 69. No particular form of words is necessary to create a warranty. SEC 70. Without prejudice to Section 51, every express warranty, made at or before the execution of a policy, must be contained in the policy itself, or in another instrument signed by the insured and referred to in the policy as making a part of it. SEC 71. A statement in a policy, of a matter relating to the person or thing insured, or to the risk, as fact, is an express warranty thereof. SEC 72. A statement in a policy, which imparts that it is intended to do or not to do a thing which materially affects the risk, is a warranty that such act or omission shall take place. SEC 73. When, before the time arrives for the performance of a warranty relating to the future, a loss insured against happens, or performance becomes unlawful at the place of the contract, or impossible, the omission to fulfill the warranty does not avoid the policy. SEC 74. The violation of a material warranty, or other material provision of a policy, on the part of either party thereto, entitles the other to rescind. SEC 75. A policy may declare that a violation of specified provisions thereof shall avoid it, otherwise the breach of an immaterial provision does not avoid the policy. SEC 76. A breach of warranty without fraud merely exonerates an insurer from the time that it occurs, or where it is broken in its inception, prevents the policy from attaching to the risk. Title 8. Premium. SEC 77. An insurer is entitled to payment of the premium as soon as the thing insured is exposed to the peril insured against. Notwithstanding any agreement to the contrary, no policy or contract of insurance issued by an insurance company is valid and binding unless and until the premium thereof has been paid, except in the case of a life or an industrial life policy whenever the grace period provision applies, or whenever under the broker and agency agreements with duly licensed intermediaries, a 90-day credit extension is given. No credit extension to a duly licensed intermediary should exceed 90 days from date of issuance of the policy. SEC 78. Employees of the Republic of the Philippines, including its political subdivisions and instrumentalities, and government-owned or controlled corporations, may pay their insurance premiums and loan obligations through salary deduction, provided that the treasurer, cashier, paymaster, or official of the entity employing the government employee is authorized, notwithstanding the provisions of any existing law, rules, and regulations to the contrary, to make deductions from the salary, wage or income of the latter pursuant to the agreement between the insurer and the government employee and to remit such deductions to the insurer concerned, and collect such reasonable fee for its services. SEC 79. An acknowledgement in a policy or contract of insurance or the receipt of premium is conclusive evidence of its payment, so far as to make the policy binding, notwithstanding any stipulation therein that it shall not be binding until the premium is actually paid. SEC 80. A person insured is entitled to a return of premium, as follows. A. To the whole premium if no part of his interest in the thing insured be exposed to any of the perils insured against. B. Where the insurance is made for a definite period of time and the insured surrenders his policy, to such portion of the premium as corresponds with the unexpired time, at a pro rata rate, unless a short period rate has been agreed upon and appears on the face of the policy, after deducting from the whole premium any claim for loss or damage under the policy which has previously accrued, provided that no holder of a life insurance policy may avail himself of the privileges of this paragraph without sufficient cause as otherwise provided by law. SEC 81. If a peril insured against has existed, and the insurer has been liable for any period, however short, the insured is not entitled to return of premiums, so far as that particular risk is concerned. SEC 82. A person insured is entitled to a return of the premium when the contract is voidable, and subsequently annulled under the provisions of the Civil Code, or on account of the fraud or misrepresentation of the insurer, or of his agent, or on account of facts, or the existence of which the insured was ignorant of without his fault, or when by any default of the insured other than actual fraud, the insurer never incurred any liability under the policy. A person insured is not entitled to a return of premium if the policy is annulled, rescinded, or if a claim is denied by reason of fraud. SEC 83. In case of an over-insurance by several insurers other than life, the insured is entitled to a ratable return of the premium, proportion to the amount by which the aggregate sum insured in all the policies exceeds the insurable value of the thing at risk. SEC 84. An insurer may contract and accept payments, in addition to regular premium, for the purpose of paying future premiums on the policy or to increase the benefits thereof. Title 9. Loss. SEC 85. An agreement not to transfer the claim of the insured against the insurer after the loss has happened, is void if made before the loss except as otherwise provided in the case of life insurance. SEC 86. Unless otherwise provided by the policy, an insurer is liable for a loss of which a peril insured against was the proximate cause, although a peril not contemplated by the contract may have been a remote cause of the loss, but he is not liable for a loss of which the peril insured against was only a remote cause. SEC 87. An insurer is liable where the thing insured is rescued from a peril insured against that would otherwise have caused a loss, if, in the course of such rescue, the thing is exposed to a peril not insured against, which permanently deprives the insured of its possession, in whole or in part, or where a loss is caused by efforts to rescue the thing insured from a peril insured against. SEC 88. Where a peril is especially accepted in a contract of insurance, a loss, which would not have occurred but for such peril, is thereby accepted although the immediate cause of the loss was a peril which was not accepted. SEC 89. An insurer is not liable for a loss caused by the willful act or through the connivance of the insured, but he is not exonerated by the negligence of the insured, or of the insurance agents or others. Title 10. Notice of loss. SEC 90. In case of loss upon an insurance against fire, an insurer is exonerated, if written notice thereof be not given to him by an insured, or some person entitled to the benefit of the insurance, without unnecessary delay. For other non-life insurance, the Commissioner may specify the period for the submission of the notice of loss. SEC 91. When a preliminary proof of loss is required by a policy, the insured is not bound to give such proof as would be necessary in a court of justice, but it is sufficient for him to give the best evidence which he has in his power at the time. SEC 92. All defects in a notice of loss, or in preliminary proof thereof, which the insured might remedy, and which the insurer omits to specify to him, without unnecessary delay, as grounds of objection, are waived. SEC 93. Delay in the presentation to an insurer of notice or proof of loss is waived if caused by any act of him, or if he omits to take objection promptly and specifically upon that ground. SEC 94. If the policy requires, by way of preliminary proof of loss, the certificate or testimony of a person other than the insured, it is sufficient for the insured to use reasonable diligence to procure it, and in case of the refusal of such person to give it, then to furnish reasonable evidence to the insurer that such refusal was not induced by any just grounds of disbelief in the facts necessary to be certified or testified. Title 11. Double insurance. SEC 95. A double insurance exists where the same person is insured by several insurers separately in respect to the same subject and interest. SEC 96. Where the insured in a policy other than life is over-insured by double insurance. A. The insured, unless the policy otherwise provides, may claim payment from the insurers in such order as he may select, up to the amount for which the insurers are severally liable under their respective contracts. B. Where the policy under which the insured claims is a valued policy, any sum received by him under any other policy shall be deducted from the value of the policy without regard to the actual value of the subject matter insured. C. Where the policy under which the insured claims is an unvalued policy, any sum received by him under any policy shall be deducted against the full insurable value, for any sum received by him under any policy. D. Where the insured receives any sum in excess of the valuation in the case of valued policies, or of the insurable value in the case of unvalued policies, he must hold such sum in trust for the insurers, according to their right of contribution among themselves. E. Each insurer is bound, as between himself and the other insurers, to contribute ratably to the loss in proportion to the amount for which he is liable under his contract. Title 12. Reinsurance. SEC 97. A contract of reinsurance is one by which an insurer procures a third person to insure him against loss or liability by reason of such original insurance. SEC 98. Where an insurer obtains reinsurance, except under automatic reinsurance treaties, he must communicate all the representations of the original insured, and also all the knowledge and information he possesses, whether previously or subsequently acquired, which are material to the risk. SEC 99. A reinsurance is presumed to be a contract of indemnity against liability, and not merely against damage. SEC 100. The original insured has no interest in a contract of reinsurance. Chapter 2. Classes of insurance. Title I. Marine insurance. Subtitle 1A. Definition. SEC 101. Marine insurance includes: A. Insurance against loss of or damage to 1. Vessels, craft, aircraft, vehicles, goods, freights, cargoes, merchandise, effects, disbursements, profits, monies, securities, choses in action, instruments of debts, valuable papers, bottomry and respondentia interests and all other kinds of property and interests therein, in respect to, appertaining to, or in connection with any and all risks or perils of navigation, transit or transportation, or while being assembled, packed, crated, baled, compressed, or similarly prepared for shipment, or while awaiting shipment, or during any delays, storage, transshipment, or reshipment incident thereto, including war risks, marine builders risks, and all personal property floater risks. 2. Person or property in connection with or appertaining to a marine, inland marine, transit or transportation insurance, including liability for loss of or damage arising out of or in connection with the construction, repair, operation, maintenance, or use of the subject matter of such insurance, but not including life insurance or surety bonds nor insurance against loss by reason of bodily injury to any person arising out of ownership, maintenance, or use of automobiles. 3. Precious stones, jewels, jewelry, precious metals, whether in course of transportation or otherwise, and 4. Bridges, tunnels and other instrumentalities of transportation and communication, excluding buildings, their furniture and furnishings, fixed contents and supplies held in storage, piers, wharves, docks and slips, and other aids to navigation and transportation, including dry docks and marine railways, dams and appurtenant facilities for the control of waterways. B. Marine protection and indemnity insurance, meaning insurance against, or against legal liability of the insured for loss, damage, or expense incident to ownership, operation, chartering, maintenance, use, repair, or construction of any vessel, craft, or instrumentality in use of ocean or inland waterways, including liability of the insured for personal injury, illness, or death or for loss of or damage to the property of another person. Subtitle 1B. Insurable interest. SEC 102. The owner of a ship has in all cases an insurable interest in it, even when it has been chartered by one who covenants to pay him its value in case of loss, provided that in this case the insurer shall be liable for only that part of the loss which the insured cannot recover from the charterer. SEC 103. The insurable interest of the owner of the ship hypothecated by bottomry is only the excess of its value over the amount secured by bottomry. SEC 104. Freightage, in the sense of a policy of marine insurance, signifies all the benefits derived by the owner, either from the chartering of the ship or its employment for the carriage of his own goods or those of others. SEC 105. The owner of a ship has an insurable interest in expected freightage which according to the ordinary and probable course of things he would have earned but for the intervention of a peril insured against or other peril incident to the voyage. SEC 106. The interest mentioned in the last section exists, in case of a charter party, when the ship has broken ground on the chartered voyage. If a price is to be paid for the carriage of goods, it exists when they are actually on board, or there is some contract for putting them on board, and both ship and goods are ready for the specified voyage. SEC 107. One who has an interest in the thing from which profits are expected to proceed has an insurable interest in the profits. SEC 108. The charterer of a ship has an insurable interest in it, to the extent that he is liable to be damnified by its loss. Subtitle 1C. Concealment. SEC 109. In marine insurance, each party is bound to communicate, in addition to what is required by Section 28, all the information which he possesses, material to the risk, except such as is mentioned in Section 30, and to state the exact and whole truth in relation to all matters that he represents, or upon inquiry discloses or assumes to disclose. SEC 110. In marine insurance, information of the belief or expectation of a third person, in reference to a material fact, is material. SEC 111. A person insured by a contract of marine insurance is presumed to have knowledge, at the time of insuring, of a prior loss, if the information might possibly have reached him in the usual mode of transmission and at the usual rate of communication. SEC 112. A concealment in a marine insurance, in respect to any of the following matters, does not vitiate the entire contract, but merely exonerates the insurer from a loss resulting from the risk concealed. A. The national character of the insured. B. The liability of the thing insured to capture and detention. C. The liability to seizure from breach of foreign laws of trade. D. The want of necessary documents, and E. The use of false and simulated papers. Subtitle 1D. Representation. SEC 113. If a representation by a person insured by a contract of marine insurance, is intentionally false in any material respect, or in respect of any fact on which the character and nature of the risk depends, the insurer may rescind the entire contract. SEC 114. The eventual falsity of a representation as to expectation does not, in the absence of fraud, avoid a contract of marine insurance. Subtitle 1A. Implied warranties. SEC 115. In every marine insurance upon a ship or freight, or freightage, or upon anything which is the subject of marine insurance, a warranty is implied that the ship is seaworthy. SEC 116. A ship is seaworthy when reasonably fit to perform the service and to encounter the ordinary perils of the voyage contemplated by the parties to the policy. SEC 117. An implied warranty of seaworthiness is complied with if the ship be seaworthy at the time of the commencement of the risk, except in the following cases. A. When the insurance is made for a specified length of time, the implied warranty is not complied with unless the ship be seaworthy at the commencement of every voyage it undertakes during that time. B. When the insurance is upon the cargo which, by the terms of the policy, description of the voyage, or established custom of the trade, is to be transhipped at an intermediate port, the implied warranty is not complied with unless each vessel upon which the cargo is shipped, or transshipped, be seaworthy at the commencement of each particular voyage. SEC 118. A warranty of seaworthiness extends not only to the condition of the structure of the ship itself, but requires that it be properly laden, and provided with a competent master, a sufficient number of competent officers and seamen, and the requisite appurtenances and equipment, such as ballasts, cables and anchors, cordage and sails, food, water, fuel and lights, and other necessary or proper stores and implements for the voyage. SEC 119. Where different portions of the voyage contemplated by a policy differ in respect to the things requisite to make the ship seaworthy, therefore, a warranty of seaworthiness is complied with if, at the commencement of each portion, the ship is seaworthy with reference to that portion. SEC 120. When the ship becomes unseaworthy during the voyage to which an insurance relates, An unreasonable delay in repairing the defect exonerates the insurer on ship or shipowner's interest from liability from any loss arising therefrom. SEC 121. A ship which is seaworthy for the purpose of an insurance upon the ship may, nevertheless, by reason of being unfitted to receive the cargo, be unseaworthy for the purpose of insurance upon the cargo. SEC 122. Where the nationality or neutrality of a ship or cargo is expressly warranted, it is implied that the ship will carry the requisite documents to show such nationality or neutrality and that it will not carry any documents which cast reasonable suspicion thereon. Subtitle 1F. The Voyage and Deviation. SEC 123. When the voyage contemplated by a marine insurance policy is described by the places of beginning and ending, the voyage insured is one which conforms to the course of sailing fixed by mercantile usage between those places. SEC 124. If the course of sailing is not fixed by mercantile usage, the voyage insured by a marine insurance policy is that way between the places specified, which to a master of ordinary skill and discretion, would mean the most natural, direct, and advantageous. SEC 125. Deviation is a departure from the course of the voyage insured, mentioned in the last two sections, or an unreasonable delay in pursuing the voyage or the commencement of an entirely different voyage. SEC 126. A deviation is proper. A. When caused by circumstances over which neither the master nor the owner of the ship has any control. B. When necessary to comply with a warranty, or to avoid a peril, whether or not the peril is insured against. C. When made in good faith, and upon reasonable grounds of belief in its necessity to avoid a peril, or D. When made in good faith, for the purpose of saving human life or relieving another vessel in distress. SEC 127. Every deviation not specified in the last section is improper. SEC 128. An insurer is not liable for any loss happening to the thing insured subsequent to an improper deviation. Subtitle 1G. Loss. SEC 129. A loss may be either total or partial. SEC 130. Every loss which is not total is partial. SEC 131. A total loss may be either actual or constructive. SEC 132. An actual total loss is caused by A. A total destruction of the thing insured. B. The irretrievable loss of the thing by sinking, or by being broken up. C. Any damage to the thing which renders it valueless to the owner for the purpose for which he held it, or D. Any other event which effectively deprives the owner of the possession, at the port of destination, of the thing insured. SEC 133. A constructive total loss is one which gives to a person insured a right to abandon, under Section 141. SEC 134. An actual loss may be presumed from the continued absence of a ship without being heard of. The length of time which is sufficient to raise this presumption depends on the circumstances of the case. SEC 135. When a ship is prevented, at an intermediate port, from completing the voyage, by the perils insured against, the liability of a marine insurer on the cargo continues after they are thus reshipped. Nothing in this section shall prevent an insurer from requiring an additional premium if the hazard be increased by this extension of liability. SEC 136. In addition to the liability mentioned in the last section, a marine insurer is bound for damages, expenses of discharging, storage, reshipment, extra freightage, and all other expenses incurred in saving cargo reshipped pursuant to the last section, up to the amount insured. Nothing in this or in the preceding section shall render a marine insurer liable for any amount in excess of the insured value or, if there be none, of the insurable value. SEC 137. Upon an actual total loss, a person insured is entitled to payment without notice of abandonment. SEC 138. where it has been agreed that an insurance upon a particular thing, or class of things, shall be free from particular average, a marine insurer is not liable for any particular average loss not depriving the insured of the possession, at the port of destination, of the whole of such thing, or class of things, even though it becomes entirely worthless, but such insurer is liable for his proportion of all general average loss assessed upon the thing insured. SEC 139. An insurance confined in terms to an actual loss does not cover a constructive total loss, but covers any loss, which necessarily results in depriving the insured of the possession, at the port of destination, of the entire thing insured. Subtitle 1H. Abandonment. SEC 140. Abandonment, in marine insurance, is the act of the insured by which, after a constructive total loss, he declares the relinquishment to the insurer of his interest in the thing insured. SEC 141. A person insured by a contract of marine insurance may abandon the thing insured, or any particular portion thereof separately valued by the policy, or otherwise separately insured, and recover for a total loss thereof, when the cause of the loss is a peril insured against. A. If more than 3/4 thereof in value is actually lost, or would have to be expended to recover it from the peril. B. If it is injured to such an extent as to reduce its value more than 3/4. C. If the thing insured is a ship, and the contemplated voyage cannot be lawfully performed without incurring either an expense to the insured of more than 3/4, the value of the thing abandoned, or a risk which a prudent man would not take under the circumstances, or D. If the thing insured, being cargo, or freightage, and the voyage cannot be performed, nor another ship procured by the master, within a reasonable time and with reasonable diligence, to forward the cargo, without incurring the like expense or risk mentioned in the preceding subparagraph. But freightage cannot in any case be abandoned unless the ship is also abandoned. SEC 142. An abandonment must be neither partial nor conditional. SEC 143. An abandonment must be made within a reasonable time after receipt of reliable information of the loss, but where the information is of a doubtful character, the insured is entitled to a reasonable time to make inquiry. SEC 144. Where the information upon which an abandonment has been made proves incorrect, or the thing insured was so far restored when the abandonment was made that there was then in fact no total loss, the abandonment becomes ineffectual. SEC 145. Abandonment is made by giving notice thereof to the insurer, which may be done orally, or in writing, provided, that if the notice be done orally, a written notice of such abandonment shall be submitted within 7 days from such oral notice. SEC 146. A notice of abandonment must be explicit, and must specify the particular cause of the abandonment, but need state only enough to show that there is probable cause therefor, and need not be accompanied with proof of interest or of loss. SEC 147. An abandonment can be sustained only upon the cause specified in the notice thereof. SEC 148. An abandonment is equivalent to a transfer by the insured of his interest to the insurer, with all the chances of recovery and indemnity. SEC 149. If a marine insurer pays for a loss as if it were an actual total loss, he is entitled to whatever may remain of the thing insured, or its proceeds or salvage, as if there had been a formal abandonment. SEC 150. Upon an abandonment, acts done in good faith by those who were agents of the insured in respect to the thing insured, subsequent to the loss, are at the risk of the insurer, and for his benefit. SEC 151. Where notice of abandonment is properly given, the rights of the insured are not prejudiced by the fact that the insurer refuses to accept the abandonment. SEC 152. The acceptance of an abandonment may be either express or implied from the conduct of the insurer. The mere silence of the insurer for an unreasonable length of time after notice shall be construed as an acceptance. SEC 153. The acceptance of an abandonment, whether express or implied, is conclusive upon the parties, and admits the loss and the sufficiency of the abandonment. SEC 154. An abandonment once made and accepted is irrevocable, unless the ground upon which it was made proves to be unfounded. SEC 155. On an accepted abandonment of a ship, freightage earned previous to the loss belongs to the insurer of said freightage, but freightage subsequently earned belongs to the insurer of the ship. SEC 156. If an insurer refuses to accept a valid abandonment, he is liable as upon an actual total loss, deducting from the amount any proceeds of the thing insured which may have come to the hands of the insured. SEC 157. If a person insured omits to abandon, he may nevertheless recover his actual loss. Subtitle 1I. Measure of indemnity. SEC 158. A valuation in a policy of marine insurance is conclusive between the parties thereto in the adjustment of either a partial or total loss, if the insured has some interest at risk, and there is no fraud on his part, except that when a thing has been hypothecated by bottomry or respondentia, before its insurance, and without the knowledge of the person actually procuring the insurance, he may show the real value. But a valuation fraudulent in fact, entitles the insurer to rescind the contract. SEC 159. A marine insurer is liable upon a partial loss, only for such proportion of the amount insured by him as the loss bears to the value of the whole interest of the insured in the property insured. SEC 160. Where profits are separately insured in a contract of marine insurance, the insured is entitled to recover, in case of loss, a proportion of such profits equivalent to the proportion which the value of the property lost bears to the value of the whole. SEC 161. In case of a valued policy of marine insurance on freightage or cargo, if a part only of the subject is exposed to risk, the valuation applies only in proportion to such part. SEC 162. When profits are valued and insured by a contract of marine insurance, a loss of them is conclusively presumed from a loss of the property out of which they are expected to arise, and the valuation fixes their amount. SEC 163. In estimating a loss under an open policy of marine insurance, the following rules are to be observed. A. The value of a ship is its value at the beginning of the risk, including all articles or charges which add to its permanent value or which are necessary to prepare it for the voyage insured. B. The value of the cargo is its actual cost to the insured, when laden on board, or where the cost cannot be ascertained, its market value at the time and place of lading, adding the charges incurred in purchasing and placing it on board, but without reference to any loss incurred in raising money for its purchase, or to any drawback on its exportation, or to the fluctuation of the market at the port of destination, or to expenses incurred on the way or on arrival. C. The value of freightage is the gross freightage, exclusive of primage, without reference to the cost of earning it, and D. The cost of insurance is in each case to be added to the value thus estimated. SEC 164. If cargo insured against partial loss arrives at the port of destination in a damaged condition, the loss of the insured is deemed to be the same proportion of the value which the market price at that port, of the thing so damaged, bears to the market price it would have brought if sound. SEC 165. A marine insurer is liable for all the expenses attendant upon a loss which forces the ship into port to be repaired, and where it is stipulated in the policy that the insured shall labor for the recovery of the property, the insurer is liable for the expense incurred thereby, such expense, in either case, being in addition to a total loss, if that afterwards occurs. SEC 166. A marine insurer is liable for a loss falling upon the insured, through a contribution in respect to the thing insured, required to be made by him towards a general average loss called for by a peril insured against, provided, that the liability of the insurer shall be limited to the proportion of contribution attaching to his policy value where this is less than the contributing value of the thing insured. SEC 167. When a person insured by a contract of marine insurance has a demand against others for contribution, he may claim the whole loss from the insurer, subrogating him to his own right to contribution. But no such claim can be made upon the insurer after the separation of the interests liable to contribution, nor when the insured, having the right and opportunity to enforce contribution from others, has neglected or waived the exercise of that right. SEC 168. In the case of a partial loss of ship or its equipment, the old materials are to be applied towards payment for the new. Unless otherwise stipulated in the policy, a marine insurer is liable for only two-thirds of the remaining cost of repairs after such deduction, except that anchors must be paid in full. Title II. Fire Insurance. SEC 169. As used in this code, the term fire insurance shall include insurance against loss by fire, lightning, windstorm, tornado, or earthquake and other allied risks, when such risks are covered by extension to fire insurance policies or under separate policies. SEC 170. An alteration in the use or condition of a thing insured from that to which it is limited by the policy made without the consent of the insurer, by means within the control of the insured, and increasing the risks, entitles an insurer to rescind a contract of fire insurance. SEC 171. An alteration in the use or condition of a thing insured from that to which it is limited by the policy, which does not increase the risk, does not affect a contract of fire insurance. SEC 172. A contract of fire insurance is not affected by any act of the insured subsequent to the execution of the policy, which does not violate its provisions, even though it increases the risk and is the cause of the loss. SEC 173. If there is no valuation in the policy, the measure of indemnity in an insurance against fire is the expense it would be to the insured at the time of the commencement of the fire to replace the thing lost or injured in the condition in which it was at the time of the injury, but if there is a valuation in a policy of fire insurance, the effect shall be the same as in a policy of marine insurance. SEC 174. Whenever the insured desires to have a valuation named in his policy, insuring any building or structure against fire, he may require such building or structure to be examined by an independent appraiser, and the value of the insured's interest therein may then be fixed as between the insurer and the insured. The cost of such examination shall be paid for by the insured. A clause shall be inserted in such policy stating substantially that the value of the insured's interest in such building or structure has been thus fixed. In the absence of any change increasing the risk without the consent of the insurer or of fraud on the part of the insured, then in case of a total loss under such policy, the whole amount so insured upon the insured's interest in such building or structure, as stated in the policy upon which the insurers have received a premium, shall be paid, and in case of a partial loss the full amount of the partial loss shall be so paid, and in case there are two or more policies covering the insured's interest therein, each policy shall contribute pro rata to the payment of such whole or partial loss. But in no case shall the insurer be required to pay more than the amount thus stated in such policy. This section shall not prevent the parties from stipulating in such policies concerning the repairing, rebuilding or replacing of buildings or structures wholly or partially damaged or destroyed. SEC 175. No policy of fire insurance shall be pledged, hypothecated, or transferred to any person, firm, or company who acts as agent for or otherwise represents the issuing company, and any such pledge, hypothecation, or transfer hereafter made shall be void and of no effect insofar as it may affect other creditors of the insured. Title III. Casualty Insurance. SEC 176. Casualty insurance is insurance covering loss or liability arising from accident or mishap, excluding certain types of loss which by law or custom are considered as falling exclusively within the scope of other types of insurance such as fire or marine. It includes, but is not limited to, employer's liability insurance, motor vehicle liability insurance, plate glass insurance, burglary and theft insurance, personal accident and health insurance as written by non-life insurance companies, and other substantially similar kinds of insurance. Title 4. Suretyship. SEC 177. A contract of suretyship is an agreement whereby a party called the surety guarantees the performance by another party called the principal or obligor of an obligation or undertaking in favor of a third party called the obligee. It includes official recognizances, stipulations, bonds, or undertakings issued by any company by virtue of and under the provisions of Act No. 536, as amended by Act No. 2206. SEC 178. The liability of the surety or sureties shall be joint and several with the obligor and shall be limited to the amount of the bond. It is determined strictly by the terms of the contract of suretyship in relation to the principal contract between the obligor and the obligee. SEC 179. The surety is entitled to payment of the premium as soon as the contract of suretyship or bond is perfected and delivered to the obligor. No contract of suretyship or bonding shall be valid and binding unless and until the premium therefore has been paid, except where the obligee has accepted the bond, in which case the bond becomes valid and enforceable irrespective of whether or not the premium has been paid by the obligor to the surety, provided that if the contract of suretyship or bond is not accepted by, or filed with the obligee, the surety shall collect only a reasonable amount, not exceeding 50%, of it. Premium due thereon as service fee plus the cost of stamps or other taxes imposed for the issuance of the contract or bond, provided, however, that if the non-acceptance of the bond be due to the fault or negligence of the surety, no such service fee, stamps or taxes shall be collected. In the case of a continuing bond, the obligor shall pay the subsequent annual premium as it falls due until the contract of suretyship is cancelled by the obligee or by the commissioner or by a court of competent jurisdiction, as the case may be. SEC 180. Pertinent provisions of the Civil Code of the Philippines shall be applied in a supplementary character whenever necessary in interpreting the provisions of a contract of suretyship. Title 5. Life Insurance. SEC 181. Life insurance is insurance on human lives and insurance appertaining thereto or connected therewith. Every contract or undertaking for the payment of annuities including contracts for the payment of lump sums under a retirement program where a life insurance company manages or acts as a trustee for such retirement program shall be considered a life insurance contract for purposes of this code. SEC 182. An insurance upon life may be made payable on the death of the person, or on his surviving a specified period, or otherwise contingently on the continuance or cessation of life. Every contract or pledge for the payment of endowments or annuities shall be considered a life insurance contract for purposes of this code. In the absence of a judicial guardian, the father, or in the latter's absence or incapacity, the mother, of any minor, who is an insured or a beneficiary under a contract of life, health, or accident insurance, may exercise, in behalf of said minor, any right under the policy, without necessity of court authority or the giving of a bond, where the interest of the minor in the particular act involved does not exceed 500,000 pesos, p. 500,000.00, or in such reasonable amount as may be determined by the Commissioner. Such right may include, but shall not be limited to, obtaining a policy loan, surrendering the policy, receiving the proceeds of the policy, and giving the minor's consent to any transaction on the policy. In the absence or in case of the incapacity of the father or mother, the grandparent, the eldest brother or sister at least 18 years of age, or any relative who has actual custody of the minor insured or beneficiary, shall act as a guardian without need of a court order or judicial appointment as such guardian, as long as such person is not otherwise disqualified or incapacitated. Payment made by the insurer pursuant to this section shall relieve such insurer of any liability under the contract. SEC 183. The insurer in a life insurance contract shall be liable in case of suicide only when it is committed after the policy has been in force for a period of 2 years from the date of its issue or of its last reinstatement, unless the policy provides a shorter period, provided, however, that suicide committed in the state of insanity shall be compensable regardless of the date of commission. SEC 184. A policy of insurance upon life or health may pass by transfer, will or succession to any person, whether he has an insurable interest or not, and such person may recover upon it whatever the insured might have recovered. SEC 185. Notice to an insurer of a transfer or bequest thereof is not necessary to preserve the validity of a policy of insurance upon life or health, unless thereby expressly required. SEC 186. Unless the interest of a person insured is susceptible of exact pecuniary measurement, the measure of indemnity under a policy of insurance upon life or health is the sum fixed in the policy. Title VI. Microinsurance. SEC 187. Microinsurance is a financial product or service that meets the risk protection needs of the poor where a. The amount of contributions, premiums, fees, or charges, computed on a daily basis, does not exceed 7.5%, 7.5%, of the current daily minimum wage rate for non-agricultural workers in Metro Manila, and b. The maximum sum of guaranteed benefits is not more than 1,000 times of the current daily minimum wage rate for non-agricultural workers in Metro Manila. SEC 188. No insurance company or mutual benefit association shall engage in the business of microinsurance unless it possesses all the requirements as may be prescribed by the Commissioner. The Commissioner shall issue such rules and regulations governing microinsurance. Chapter III. Financial Reporting Framework. SEC 189. All companies regulated by the Commission, unless otherwise required by law, should comply with the financial reporting frameworks adopted by the Commission for purposes of creating the statutory financial reports and the annual statements to be submitted to the Commission. Financial reporting framework means a set of accounting and reporting principles, standards, interpretations, and pronouncements that must be adopted in the preparation and submission of the statutory financial statements and reports required by the Commission. This financial reporting framework is not the same as the financial reporting framework used to prepare the financial statements that the Securities and Exchange Commission may require. The main purpose of the statutory statements is to present important information about the level of risk and solvency situation of insurers. In prescribing the applicable statutory financial reporting framework, the Commissioner shall take into account international standards concerning solvency and insurance company reporting as well as generally accepted actuarial principles concerning financial reporting promulgated by the Actuarial Society of the Philippines. The assets and investments discussed in sections 204 to 215 shall be accounted for in accordance with this section. The valuation of reserves shall be accounted for in accordance with Title V of this Code.